Hello, this is Antonio Gangali. I'll be discussing the issues of government misconduct, John Meyer's death by suicide, and the right to be heard. John was hired at Union Cheese. I believe he had worked there for possibly 18 months. He started on, it's called the universal vats. It's where the curd went into the vats, where the whey got drained off and pressed into blocks of cheese. And then in the mornings, it'd be cut into 200-pound blocks and placed in the brine. And in the process, he was beginning to learn to make cheese. So he started out, we were probably at 30% capacity. So ultimately, actually, the day of shutdown, we were at 100% capacity. We ran 6 days a week, and then I had several projects I would do, and he would help occasionally on those, so like regassing the high temperature short time pasteurizer plates, regasketing the separators, or tearing down and cleaning. We had pasteurized the brine. So John was a great help, and if you kind of understand a dairy's function and whatnot, cheesemaker's a fairly high position in the company. For him to be in the process of becoming a cheesemaker tells a lot of. So when the order came down, it was basically just dumped on us, and it was actually quite confusing. Before John's death, he had came, and this was after the supplemental order. So that the supplemental order, I believe, was July 11th or so. So, I don't know, several days after or what, John came and discussed, we determined that we would cease operations. In our perspective, the order was just too oppressive, and the threats of civil and criminal contempt and the countless mandates and the things that had transpired with the Food and Drug Administration throughout. And the order was actually quite difficult to understand, or didn't believe that it was even possible. So we'll get into, and John had some of the similar questions. So we were struggling with how the court really came to its findings and what. So I'll briefly get into some things. I have a YouTube that kind of gets into a lot more, but briefly, the FDA imposed a zero tolerance policy for Listeria mono in the processing area. The federal court order also expanded it to all other pathogenic bacteria. So it's quite oppressive when you consider that the FDA reported that there was 13% of the Midwest raw milk supply contained Listeria mono. So it seems troubling of how you would bring in milk to your facility, and it seemed like it was conflicting with federal law. And why I say that is 21 Code of Federal Regulations 133-195, the standards of identity of natural Swiss cheese provides that you can use raw milk. So if you can use raw milk in the facility and it gives you 90 days to age that product, so if you were given 90 days, it doesn't seem rational that you would prohibit Listeria mono in your plant or other pathogens. Further, federal law provided that cheese could be made from unpasteurized milk. So there were like two statutes that federal law clearly recognized this process. So when the FDA implemented this zero tolerance policy, does it conflict with well-established law? And so why was the judge creating this new law or revising it? So we were pretty perplexed. So I believe that there'd be issues of arbitrary and capricious, and if the FDA was willfully ignoring federal law. During the meeting, or you'd ask, well, what about the other facilities? Because Sugar Creek is basically the center of the natural Swiss cheese capital of the world. So there was multiple dairies in the area, and are they having to comply with this new law? And what was unique is Union was a USDA-approved make facility, which is voluntary status. So in general, we were a state-of-the-art facility. It would seem, as well as that there was no Listeria found during the court-ordered inspection. So why we were being subjected to things, and it seemed like we were a better facility than many in the area. So we're having a hard time understanding when this was going to get enforced, or why they wasn't being applied to other industry, other company. Especially, it was about a month into it, and it didn't seem like they were going after them. And I'll later discover of the Public Citizens versus Heckler, where they changed and required the pasteurization of products. Well, so what's kind of interesting is it seems to be similar, or that they were forging new law in Citizens versus Heckler. and it required the Secretary of Health and Human Services to publish within the Federal Registry. So I guess in retrospect, I guess the things that we were questioning is, or the mandates and whatnot, is why this wouldn't have been subjected to publication in the Federal Registry of these mandates. So, and if it's not being published, was there issues of discrimination? And if this is being uniformly applied, were they depriving rights or privileges under the law? And was it willful? So you want to go further if you were examining things about that, is like the Fourth Amendment. So they were in the facility multiple times, one going on 3 weeks. And the one, December 14th, the big blowout, was actually, there were several things within John's department. There would be issues if there were Fourth Amendment violations. And did the government make it costly to exercise those rights? Further, there was the issue is that the judge came to findings of fact saying that the evidence is clear that the levels of Listeria mono is increased through intervening acts of humans during the cheese-making process. And that dumbfounded us, particularly when you do a federal search and no Listeria mono was found. So I don't know how you would assert that it would be increased. Further, when you kind of look at that is, so at what point were they asserting that it was the levels were increased? And you even go into further is like, who would they be pointing fingers at if this was an issue? And when you consider that Union was a state-of-the-art facility, and if they're saying the cheese-making process, well, there's basically, I believe there's around 5 people in production. And if you're going to assert that it was somebody from intake or during night sanitation, so that would basically be lowering the levels of any possible. If you assert that it was the cheesemaker, is it was running through a high temperature short time, and you're getting 99.99, a 5-log reduction of microorganisms in the milk going into a double O, which is a contained vat. So are you asserting that it was raised during that time? So it leaves very few individuals of who they would be pointing fingers at, or who they would say were increasing it. Compounded with the understanding that during the court-ordered inspection that they were going after John's department, it would seem that this federal judge is pointing fingers at certain individuals, and they would raise issues of if they had a right to be heard or actually be able to defend their interests or rebut some of the things that this federal judge, the findings of fact. We will further discover that the declarations of the named individuals appear to be wrong, and there's issues of false declarations, and it appears that it was willful or they had knowledge to correct it, which they didn't. So that leads into a whole lot of legal issues of, well, so you have a federal trial where a federal judge ignores issues of proper people being named. It appears that they had no similarly situated person named in the litigation to defend someone's interest like that. So if you're asserting these facts and he was deprived due process, are there legal issues of that? No, people in that position had a right to be heard. And where is the Administrative Procedures Act and all that? So it opens a whole can of worms of how this judge or what this judge was doing. As I mentioned, the named individuals, it seems to be false, misleading, or inaccurate, and that there was no person with direct knowledge of the subject matter were named in this litigation. So there was no one similarly situated. It raises a whole thing of issues, as I stated, and then we get into the order itself, which forbid any Listeria mono or other pathogens, and it goes on further, and it'd be a period for 1 year. So when you think that there's 13% in the commercial milk supply, Union brought in milk every day, we had hundreds of producers, you start calculating it out, and the probability that just bringing it to the facility, not even unloading, is the trucks at the door to unload, the probability is astronomical. You're looking at 10 to the, I believe it's over 100 or 303. So just the probability of Listeria alone receiving, I calculated at 10 to the, I think is the 23rd power. And then you get to all other pathogens, and basically you're wanting sterility So we always believed that it was a virtual impossibility and one of the most oppressive orders in U.S. history. Now, where this becomes concerning is that there would be a successor corporation and that the FDA had to sign off on it and whatnot. So if it's found that this order is not possible, then there's a whole nother set of legal issues of what shenanigans were going on and how did someone manage to comply with this order if the order's not possible. So was there manipulations or were there... So clearly there was issues of discrimination, and it appears that one set of party was not being treated the same as another, and different obligations and whatnot. There was an SAT question that said everybody got wrong. So that one's interesting. So if it's not possible, how did so many people get it wrong? And how did a federal judge go through an entire federal trial and it be not possible? And where it gets even more disturbing here is we received the order on June 19th. On June 22nd, I had a call with a co-op out of New York, and he was desperately trying to get a resolution to this. And later, I had a conversation here. He had called the Food and Drug Administration, the Cincinnati office, throughout the day apparently. During our evening conversation, he explained to me that they explained things. Further explained that with those explanations, they asked if Tony could take full legal responsibility, in which there were statements made. And further, there was quite a bit of conversation I had with him. But what stuck out completely is that during that, it was going to be virtually impossible for Mr. Gangali to resume his Swiss cheese manufacturing operations. So it appears that the Food and Drug Administration knew that it was virtually impossible. So there's legal issues, I believe, that there were shenanigans going on. That behind the scenes, they knew that it was impossible, and they were either having the Department of Justice and deceiving the court, or there was a deeper agenda going on than what the public knew. And this then goes back to the issues of John and the parties not named. And here's the statistical. So milk in your silo, if it's a 13% probability, or I put, there's two reports, I believe there's 12 and a 13, so I averaged it to 12.5. And I think 12.5 is 1 out of 8, so it was easier on the calculations. Well, what's interesting is the iPhone, if you use the calculations, I believe after 22 or at some point, it just calculates it to 1. So basically full probability. And then when you examine that it was regarding other pathogens, I believe it's a near 100% probability that you would violate that order within the first day. Again, in here, you'll see that there was a failure for the FDA to find Listeria mono during the court-ordered May 1995 inspection does not convince the court. Yet, somehow it says the evidence is clear the levels of Listeria is increased. So I don't know how they're increasing when you don't find anything. So it seems like a contradiction of things. On June 16th was the order. I received it, I believe, on June 19th. It was a Monday. So it was just dumped on us that we had to close with it by the end of the day. Now here's where it gets intriguing. So if you examine the June 16th order, which was required for it to be disseminated to employees and whatnot, there's a judgment of June 23rd. Would have that been a right of appealable order? So the question is if people aren't named in the case, or they're subjecting people bound on Rule 65, people in active concert or participation with the parties are subject to the order and have to be served, is how does someone like John or myself, how do we know when the case, there's a final appealable order, if there's nothing, is there a paragraph where it says it's a final? And you're not served or you're not given notice of that. But what's even more disturbing is you're exposing the company from the 16th to the 22nd of this order. So what I'm saying is, so on 23rd, all hell was breaking loose. It was all publicly known, like it was broadcasted on the television and everything. And here, there's no ability to stay the case, or you don't know what's going on. So there's this, it's like the shot's been fired, the bell's been rung, and here is like, well, and you don't know what's going on in the case. You're basically in the dark of it. Is how do you even know what to appeal? Because you were provided no information. You didn't know what the court was doing or how it came to its determinations or what the hell this proceeding was, because it seems to clearly conflict with federal law. So were they rewriting law? Was this a case like a Citizens versus Heckler, where they were reestablishing law or revising law or whatnot? But that's not where this case really gets disturbing, because once you read the complaint, which I will read years later, then things really get disturbing. We'll notice that the declaration of John R. Mazzelli of the named individuals, it appears to be materially false, untrue, misrepresented, and inaccurate. Now that creates a legal issues of due process for the party that was the proper one or had. In that declaration, I believe it asserts that it was derived from official records and documents. And you'll see within the court docketing filings that the company had repeatedly advised them or informed them that they had the wrong party. And there was willful, conscious effort to avoid learning the truth. So it appears that it was willful. So 18 U.S. Code 1623, false declarations before a grand jury or a court, appears to be a federal crime. So are there issues that there were federal crimes here? Further, was it advocated or testified in court? Which I haven't had the transcripts, but if it is, there's 18 U.S. Code 1621 of perjury. But now we get into further Rule 65 injunctions and restraining orders, notice to adverse parties. So it would not seem to comply with Rule 65. Then there's Fifth Amendment of due process. There's Fourth Amendment of being able to challenge the Fourth Amendment search and seizure. So are those willfully depriving the rights? Then you have the deprivation of rights under the color of law, 18 U.S. Code 242. And is there a conspiracy to deprive? 18241. And then there's Rules of Procedure 19, required a joiner of parties. So are there issues that the Justice Department is a party to this behavior? And would they have been required to recuse or notify the court that there's issues within this case? So were there Rule 11, the representations to the court, was there misrepresentations that the U.S. Attorneys should have corrected? So basically, were they aiding and abetting a federal crime? Were they accessories or complicit? Was there conspiracies to commit an offense? It gets further, because then Rule 11, they would have lack of subject matter jurisdiction. So how does the court assert jurisdiction if the proper parties were not named? So are there issues that it was void? Then there's the Administrative Procedures Act, which doesn't seem to be followed, or issues regarding that. And then there's Eighth Amendment violations of cruel and unusual punishment. So it appears that the FDA knew that this was not a possible order and proceeded to allow the judgment. So are there issues of willfully depriving of right? Was it cruel and unusual punishment to have one of the most oppressive orders in U.S. history? Further, are there issues that it was constitutionally vague, and the vagueness doctrine is to prevent arbitrary enforcement of laws. So does a person understand what the requirements of them were in this case? But it gets way, 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 way more interesting than that, because that's not the only issues of federal crimes here. It appears the declaration of Joseph M. Madden, the FDA's expert witness, testified regarding possible levels in the milk. Was that materially false or misrepresented? So here's what's interesting, is again, I have a YouTube, and I get into several things within that. Within my YouTube, I have the television report. Within the television report, you'll notice, go through the facility, and there's an actual photo or of the high temperature short time. So this is broadcasted basically of Northeast Ohio, or it was the Cleveland area, which is where the judgment was, in the Northern District Court of Ohio. So the public can view that there appears to be a high temperature short time. So when you examine this gentleman's testimony, then is how did they come, or did he misrepresent or omit that I had of a high temperature short time? What was it set at, and what was the hold times and whatnot? So are there issues that he materially omits that in his analysis or testimony? And you say, well, how is that possible when the FDA was in your facility multiple times, one going on 3 weeks? Is like, there's no way that they could have missed this. And this case was filed of pathogenic bacteria. So to have this omitted is inconceivable. Is it knowingly? And they were given the ability to inspect the facility under a court order. So there's multiple things is this testimony seems to materially omit things, and he had the opportunity. So their issues is when he filed this action with the court, is it a false declaration before a court or a grand jury? So is that a federal crime? Did he use testimony? And did he misrepresent that? So is that a federal crime? Does it violate due process? Is it willful? Further, was it deprivation of rights under the color of law? Were they blatantly going against the federal standards of identity of natural Swiss cheese? So were they willfully doing that, and did they conspire to do that? So is that a federal crime? Were there representations to the court in the filings that they submitted to the court? Under Rule 11, did the U.S. Justice Department, did they correct the record that there's issues with that? Then are there issues of lack of subject matter jurisdiction? Because to assert injunctive relief, does it have to be adulterated? So if they misrepresent the manner and method to claim adulteration, and then there's no claim to adulteration, they didn't have injunctive relief. So did they lack subject matter jurisdiction on that? And again, back to the Administrative Procedures Act, is where was the right to be heard? Where is this within the federal registry of these particular things? And is there equal application of the law? And this reminds me of the filing. So within the filing, John R. Merzelli stated, "I have halted my efforts to achieve compliance voluntarily. Unless permanent injunctive release is obtained, I believe that these violations will continue. Pursuant to 28 U.S. Code 1746, I declare under the penalty of perjury if the foregoing is true and correct." Or they're mandating this zero tolerance. Is there issues that it is not a violation, or that he's asserting it to be a violation and there was no formal rulemaking to establish it as a violation? But let's go further, because there's issues that the declaration by Philip of materially omitting multiple official records prepared by the FDA indicating that my sister was a secretary. So within this court proceedings, the court had been told multiple times that they had the wrong individual. And it appears that the lead investigator files a declaration asserting it. So they are litigating a case where a secretary appears to be the primary person in charge, which is absolutely incorrect. And it appears in his declaration he omits, I believe, material facts. So are there false filings in that? Are there issues? Did he testify? Are there rules of Rule 65, due process, unreasonable search and seizure? Was there willfully depriving of rights or colors? Was there conspiracy to deprive rights? As well as the requirement of joiner of parties, representations to the court. Was there misrepresentations? Issues of subject matter jurisdiction, the issues of the Administrative Procedures Act, which the deprivation of a procedure right protected of a concrete interest is irreparable harm. So if you're going into a facility asserting zero tolerance and you didn't follow the Administrative Procedures Act, were they inflicting irreparable harm? And is there Fourth Amendment violations here of unreasonable search and seizure? So there's quite a few issues of his declaration. So that's 3 declarations in a case that appeared to be false. Then we have the issues of impossibility. So before the June 23rd judgment, it appears that Charles W. Sedgwick, director of the Compliance Cincinnati office, that conversation with Milton, the president of CCAMP, on June 22nd, it appears that he had knowledge that there was impossibility. and that there was conversations regarding myself. So are there issues that Rule 65 notice to adverse party? Was there deprivations under the color of law? Was there cruel and unusual punishment inflicted? Was there deprivation of rights under the color of law? Conspiracy to deprive rights? Violations of the Administrative Procedures Acts of irreparable harm being inflicted? And the right of review. And then it gets even more, because then was there false public statements by the spokesperson of the FDA in the television report? Because within that report, it says all Mr. Gangali has to do is fix a few things and teach his employees good food handling techniques, and he can resume operations. Well, is the order impossible? Is it statistically impossible to operate? Did he face civil and criminal contempt? And was there countless the FDA's discretion? So there were pages of mandates. In here, they're telling him the viewing audience, just a little bit. But in private conversations, does the FDA, does it assert that it's virtually impossible? So are there issues of misrepresenting to the public of what these mandates are and the oppressiveness of them. And then it gets into the June 16th order and if it was impossible. Now, if it's impossible, the FDA had to certify before operate. So if it's not possible and they asserted in writing that they were compliant, is there legal issues regarding that? And then the successor corporation is they are asserting that they complied with it. So are there parties and labs in all these individuals that had to sign off or verify compliance? So are there issues that they're in violation of a federal court order? Then are the issues that the Justice Department, are they a participant in that? But then it gets even more disturbing because the Rule 65 requires persons bound by the order as well. So according to Rule 65 is binding on the people is other people in active concert or participation with them. So if this order is not possible, now there are countless individuals violating a federal court order. And so can you create a federal court order and violate it with impunity? And that's what appears to be happening if this is impossible. When I discovered this information, I had filed an action in federal Northern District Court, and I believe it was in Gangali versus, U.S. government in this case, or the one in 1998. And under 5 U.S. Code 702, the right to review, a person suffering legal wrong because of an agency action or adversary effect or aggravated or agency action within the meaning of the relevant statute is entitled to judicial review, therefore. And here's shall not be dismissed or relief therein be denied on the grounds that it's against the United States or is an indispensable party. The United States may be named as a defendant in such action. So I attempted when I discovered some of these disturbing things to bring action. You'll see in case 5001 CV here, docket 14 filed on 4/18/01. The Northern District Court then permanently adjourned me from filing any new lawsuits or other documents with the court. So this would be twice, and this was with no hearing, no right to be heard, nothing. So this would be the second goddamn time the Northern District Court blew out rights or privileges that a United States citizen had with no hearing, no nothing. And there's a case here. Here, the plaintiff argues the suppression constitutes government action in violation of plaintiff's freedom under the First Amendment. So are there issues that there's a continuing violation of this order? Here, irreparable harm, showing of irreparable harm, injury to be irreparable, plaintiff need only show that it cannot be undone through monetary remedies. Depriving of potential, here, additionally, violating the First Amendment constitutional right, even for minimal periods of times, is always irreparable injury. Plaintiff argues in the memorandum that the First Amendment violations are continuing and there is a substantial risk that future harm will likely occur. So are the legal issues that I'm barred access and they are obstructing justice or preventing me from going into court to address these legal issues. You'll see then in 2006, 413, motion for Guggisberg Cheese Inc. to vacate injunction. Here on grounds that the prerequisite set forth in the court in this findings of fact and conclusion of law filed on June 16, 1995, said injunction terminated have been met. That's interesting. Within that filing, it appears ingredients, raw milk loads are tested and unloaded into the silo. What's odd about this is, or interesting, so when they began operations, were there producers from Union Cheese that they were bringing in milk? So the same farmers, producers, same test. Actually, was it the same driver? Was it the same truck? Was it being unloaded in the same bay? So did Tony Gangali have direct knowledge of what the bacteria counts of those producers could possibly be? Was there bacteria within that milk? And does that comply with the federal court order? Could this filing, could it have been met? So that's a federal question. Back to some of the issues, is there a right to be heard? So let's get into is how does an injured party that a federal court appears to have asserted, how does one defend themselves? And was anyone similarly situated given a right to be heard on those issues? So are there legal issues of violating due process? So how do we address someone's right to be heard in these situations when the person with primary knowledge, myself, is they didn't provide me the right to be heard, and then they bar my access to the federal courts? When I would get a lot of calls from farmers throughout the thing, they would ask who the FDA was. But when you dig deep into that question is, who are they exactly? And I mean dig deep of the founding of our fathers and what our nation encompassed and what their beliefs were. So you realize that the FDA is a law enforcement agency or an enforcement agency. They're derived through Congress. So they're not sanctioned under the Constitution, but you're giving them enforcement powers. And then you're going into federal court with using injunctions. So there's a quasi-litigation of preemptively punishing a future act. When you think about the declarations, so not only was the FDA appearing to be in direct conflict with the well-established law and bypassing the Administrative Procedures Act, and appears to misrepresent the controlling legal authority, the FDA's new policy or mandates, one, were they impossible, but here, so when you are, the FDA had known that the firm was in the midst of succession. So they knew my father was semi-retired and there's an affidavit in the filings, I believe, docket 13, stating that he took a less active role in the day-to-day management of the firm. Okay, so the FDA knew this, the court knew this. So when you are seeking permanent injunctive relief and you're punishing future acts in a quasi-litigation, and you do not name the individual that spent the entire time with the Food and Administration, and then you want to punish a future act, is there legal problems with that? How can you destroy business on future events and misrepresent named individuals and of the people that were part of its future? And then there's also the legal issues is if you're requiring to disseminate this order and it's false, does it fly in the face of violating a First Amendment right? So you're required under court order or under threat to disseminate false information. So back to the enforcement of laws is who are the primary enforcers of law? Examining, was the Second Amendment intended, is how was it written and whatnot, and was it designed that the primary enforcers of laws in the United States were the militia, and that the FDA, they're not constitutionally held. So why I get to this point? I believe that there was gross government misconduct. I believe that there were multiple federal crimes. And it's concerning to me that an individual was subjected to all these things and it wasn't investigated, or his right to be heard, or other people's right to be heard. So this government seems to be silencing people and making laws and whatnot, and it appears that they're playing some shenanigans. So many legal issues, and hopefully one day there'll be a full investigation. I believe there might have been a report on this case or on the matters. It would be an interesting read, I believe, if it exists. And I think the public would be shocked to know how many crimes or how bad that misconduct was within this case. And lastly, occasionally I'll see people writing papers or cite case law, for instance, here, within published papers or things. And what's astonishing to me is they have no comprehension of what transpired within these cases. Here, this could be one of the most oppressive cases in U.S. history, countless federal crimes and whatnot, and they're citing it. And here it could be a void case which the government refuses to address. So I believe my right to the First Amendment of being blocked access, I believe that's a continuing violation. I believe that there was misconduct, the professional responsibility of misconduct or reporting it. Like, there's just countless issues within this union case. I hope I informed a lot of people, and I want to thank you for your time. Goodbye.